A motion to suppress evidence is where a criminal defense lawyer makes an allegation that the Fourth Amendment of the United States Constitution and Article 1, Section 9 of the Oregon Constitution, both of which say that citizens are free from unreasonable searches or seizures, and that warrantless seizures are per se unreasonable, and tries to exclude or get rid of evidence in a criminal trial on the basis that the government engaged in misconduct in getting that evidence. In the history of my practice, I've had at least 200 motions to suppress evidence conceded or granted by the court. This week, a case was dismissed by the state after they had originally intended to fight the motion to suppress, but additional case law came down from the Oregon Supreme Court. Our client is a young Latinx member of our community. He was driving a rental car down I-5 when a senior trooper pulled his car over because his passenger was leaned a little bit too far back in his seat, and he believed he didn't have his seatbelt on. After quickly saying, "I'm just going to give you a warning for that," a script that we see every day far too often, particularly in marijuana interdiction cases, he said, "I think I smell a little bit of marijuana. Where are you guys coming from and where are you going to?" When the passenger and the driver didn't really want to discuss their travel plans, the officer used that and their alleged nervousness as reasons to try to search the car. They denied him consent. He nonetheless searched that car on the basis that he smelled marijuana, and they were evasive. Finding no marijuana in the vehicle and figuring out that their travel plans were as they had expressed, he nonetheless searched the trunk. In the trunk, he found a dealer amount of cocaine and some money. He seized that, arrested them, towed their car, took their cell phone, took their money, and nonetheless, thankfully, our client was able to find our office. Our client was able to get back on his feet to learn from this situation. And we filed a motion to suppress the evidence on the basis that he'd been unlawfully searched, that he'd been unlawfully seized in that interaction, that it was based on impermissible criteria, and that they were held in a state that allows legal marijuana just because an officer says that he smells a little bit of marijuana. And ultimately, the state this week conceded that case. Our client, looking at a mandatory minimum sentence of 5 years in prison despite having no criminal history, was given a second chance. His case was dismissed, and now he is able to grow into the man that we all believe he can be.